Hello everyone, welcome back to my channel Law Critics. I hope you are doing good and safe at home and keeping yourself updated with all the amendments and circulars issued by ministry and of course enjoying work from home. So as I said in previous videos, I really want to make this channel a two-way communication rather than a one-way, and therefore all your suggestions, doubts, interpretation with respect to corporate laws are always welcome to discuss on my channel. And I am very glad to say that today's topic is suggested by one of my viewer and very good friend Kinjal Momaya. Since due to the lockdown and everything, the MCA has issued a circular with respect to the convening annual general meeting through video conference, and there were no such provision earlier under Companies Act 2013. It's gonna be very big challenge for all of us with compliance point of view, and therefore my today's video will be based upon convening annual general meeting through video conference, and I'll be discussing and analyzing the circulars issued by Ministry of Corporate Affairs and SEBI. So without further delay, let's proceed. MCA issued the first circular on 8 April 2020 allowing the extraordinary general meeting through video conference. In this circular, the companies were categorized into two parts, one which are required to or opted for facilitating e-voting and another which are not required to facilitate e-voting, and specified the detailed procedure for convening EGM through video conference. Then on 13th April 2020, MCA issued another circular specifying clarification on issuing of the notice and mode of casting vote with respect to the convening EGM through video conference. Then on 21st April 2020, MCA provided the extension for holding annual general meeting for the companies whose financial year ended on 31st December 2019. The exact words in circular are, it is hereby clarified that the company whose financial year other than the first financial year has been ended on 31st December 2019 hold their annual general meeting for such financial year within period of 9 months from the closure of the financial year, that is by the 30th September 2020, the same shall not be viewed as a violation. So now if we observe provisions under section 96 of Companies Act 2013, there are two conditions for convening annual general meeting. The annual general meeting is to be conducted within 6 months from the end of the financial year, and the gap between two annual general meetings shall not exceed 15 months. Therefore, it is pertinent to note that the MCA has only provided the extension for exceeding the number of the months after the end of the financial year, but has not provided the exemption for exceeding 15-month gaps. So, if the 15-month gaps is exceeding, the company has to apply for the extension for convening annual general meeting. MCA issued the next circular on 5th May 2020, in which it allowed annual general meeting to be held through the video conference. The scope and applicability of this circular is for all the annual general meeting to be held in the calendar year 2020, irrespective of the financial year of the company, but subject to the conditions specified in a circular. And in this circular also, the companies were segregated into two parts, one which is required to or opted for facilitating e-voting, or another which are not facilitating e-voting. The detailed provisions of this circular will be covered in the next part of this video. Coming to the circulars issued by the SEBI with respect to the general meetings, the SEBI wide circular dated 26 March 2020 provided the 1 month extension to 5 months for convening annual general meeting as specified under Regulation 44(5) of LODR for the top 100 companies whose financial year ended on 31st March 2020. Then on MCA circular for providing extension for holding annual general meeting for companies whose financial year ended on 31st December 2019, the SEBI also on 23rd April 2020, in line with MCA circular, provided extension up to 30th September 2020 for these companies. Then on 12th May 2020, SEBI issued another circular providing relaxation requiring out of MCA circulars. This regulation includes Regulation 36(1)(b) and (c). This regulation provides for sending of the hard copies of annual report to those shareholders who have not registered their email address or requested for the same. This is to be noted that this exemption is available for all the annual general meeting to be held during the calendar year 2020, irrespective whether the annual general meeting is to be conducted through video conference or otherwise. Next is Regulation 44(4) of LODR. This regulation provides for sending of the proxy forms, and this exemption is available for the annual general meeting to be held through video conference during the calendar year 2020. Next is requirement under Regulation 12, which provides where it is not possible for companies to use electronic mode for the payment of dividend, warrant or check shall be couriered. However, this exemption is available only till the normalization of postal services, and company will have to send the checks or warrants upon the normalization of situation. Link of these circulars are mentioned in the description box below for your easy reference. As per the circular, the eligibility for holding annual general meeting through video conference are: first, the companies who are required to facilitate e-voting. As per Rule 20, the listed companies and the companies having more than 1000 members are required to facilitate e-voting. Second are the companies who have opted for facilitating e-voting. And third are the companies who have registered their email address of 50% of members, representing, in case of the needy company, more than the 1000 rupees face value, or 10% of paid up share capital, whichever is less. In case of the companies having share capital, representing 75% of share capital. In case of the companies not having share capital, representing 75% of voting rights. So, to ascertain whether the company is eligible to hold their annual general meeting through video conference, we shall have to check whether the company is required to or opted for facilitating e-voting. If yes, then company is eligible, and if no, then we will have to check whether the requirement of registered email address of 50% of its members, representing 75% of share capital or voting rights, is fulfilled. If yes, then company is eligible, and if no, then we will further have to check after giving the advertisement for registration of email address, the precondition is fulfilled. If yes, then company is eligible, and if no, then company cannot hold their annual general meeting through video conference. It is to be noted that requirement of registered email address in case of companies not facilitating e-voting is for combined 50% of number of members as well as 75% of share capital or voting rights. So we saw the eligibility to hold annual general meeting through video conference. But where company is not eligible or unable to hold annual general meeting through video conference, in such case company may seek for extension for holding annual general meeting, or where company can get the permission of local authority, can convene physical annual general meeting. MCA Circular provides, in case of the companies which are not required to facilitate e-voting, in order to ensure that all the members are aware that annual general meeting is to be conducted through video conference and their email address is registered with the company, shall contact them through telephone, and where contact details are not available, shall make an advertisement in one English language and one vernacular language. This advertisement shall state that annual general meeting is proposed to be held through video conference, and shall also provide contact details and email address where member can contact to get their email address registered. The purpose of this advertisement is to enable the members to get their email address registered, and therefore in case where all the members have registered their email address, this advertisement is not required to be made. MCA Circular provides, in case of the companies which are required to facilitate e-voting, before sending the notice and financial statement to members, shall make a publication in newspaper. This newspaper publication shall state that the annual general meeting is to be conducted through video conference, date and time of annual general meeting, that the notice of the meeting is available on website and on stock exchange, the manner in which the members who hold the shares in physical form or have not registered their email address can cast their vote, the manner in which the members can get their email address registered, the manner in which the members can give their mandate for receiving dividend electronically through ECS. Now coming to the provisions relating to the notice. The MCA and SEBI Circular Circular have provided a relaxation for sending the hard copies of the notice to the members, and now notice is to be sent only through the email address registered with the company. This will also help the companies in cost cutting. Further, the notice is to be displayed on website of the company. And circular also provide that the notice shall specify framework provided in circular, clear instruction how to access and participate in meeting, helpline number for the technical assistant before and during the meeting. So there are many things we will have to take care of while drafting the notice, and there will be many changes in the content of the notice. And since this is out of the recent amendments, it is very crucial in compliance point of view, especially for the listed company which are required to disseminate their notice to public and stock exchange. And therefore I have observed the notices of top few companies to understand the best practices which are made public and submitted to stock exchange. And I'll show you the relevant changes consequent to convening their annual general meeting through video conference. So let's start. This is the notice of annual general meeting of Infosys, and I have highlighted the relevant statement for an easy reference. So as we can see, the company has specified that the annual general meeting is to be conducted through video conference or other audio visual mode. Now coming down, in notes part, point 1, the company has given reference of circulars issued by the MCA and SEBI, pursuant to which annual general meeting is to be conducted through video conference. And in point 2, the company has specified that the facility for appointment of proxies by the members will not be available, and participation of members through VC will be reckoned for the purpose of quorum. And company has provided facility to upload the board resolution or authority letter on VC portal or e-voting portal for its corporate members. Further, in point number 5, the company has stated that the registers as specified under section 170 and section 189 will be available electronically for the purpose of inspection from the date of this notice up to the date of AGM, and provided email address where the request can be sought. Further, the dividend will be paid through ECS, and company requested members to update their bank details. And in compliance with the SEBI circular, the company has specified that in case of members could not be paid electronically, the checks or warrants will be couriered to them upon the normalization of postal services. Now coming down, the company has specified that the facility of e-voting will be available during the annual general meeting, and those members present who have not casted their vote through remote e-voting can cast their vote through e-voting during the annual general meeting. Then, in compliance with the MCA circular, the annual report for the financial year 1920 along with the supported document are being sent only through the electronic mode who have registered their email address with the DP or company. And in order to enable the members holding their shares through physical form or DMAT, get their email address registered and update their bank details, specify the detailed process in table. And since the annual general meeting is to be conducted through VC, the route map, proxy form and attendance slip are not attached to the notice. Now coming down, the company has provided instruction for participation through video conference in step-by-step manner, and followed by general guidance for VC participation. and also instruction for e-voting, divided into 2 steps. These are so comprehensive that any member who is not that even friendly with the system can easily participate and vote. And in point number 3, the company has specified that in case of any queries can refer to FAQs, and also provided email address and phone number. Now coming to the other provisions provided in circular. First, there shall be a two-way teleconferencing and shall allow the members to question concurrently. So while selecting the system, we shall have to ensure that this facility is available. Next is facility for joining shall kept open for 15 minutes and shall not be closed till the expiry of 15 minutes of the scheduled time. Next is attendance of members through video conference or other audio-visual mode shall be counted for the purpose of quorum. Next is at least one independent director, an auditor or his representative shall attend the meeting. So apart from this provision, the provision of LODR with respect to presence of chairman of audit committee, NRC, stakeholders relationship committee shall also require to be complied with. Next is dividend shall be paid through ECS. As we discussed in a SEBI circular, the members who could not be paid electronically, warrants or checks shall be couriered to them upon the normalization of postal services. Next is no proxy shall be allowed to participate and vote. Since the annual general meeting is to be conducted through video conference and members can attend it from anywhere, there is no requirement to appoint a proxy, and therefore circular provides the no proxy shall be allowed. Next is members may vote through e-voting during the annual general meeting, and the scrutinizer shall be appointed as per Companies Act 2013. Next is filing of all the resolution within 60 days of meeting. So all the resolution passed in annual general meeting are required to file with the ROC. The form is not specified, but it can be the form GNL 2 or MGT 14 because of its features, or there can be a further clarification on this part. Next is recorded transcript are to be maintained in a safe custody, and in case of the public company shall also be made available on website. Next is inspection of register and other documents shall be made available through electronic mode. So as we saw in the notice of Infosys, they have provided the inspection through electronic mode and specified the email address where requests can be sought. MCA Circular provides that the chairman of the meeting shall satisfy himself and cause to record before considering the business in the meeting that all the efforts feasible in the circumstances have been made by the company to enable the members to participate and vote in the meeting. And statement to this effect is also required to be noted in the minutes of the annual general meeting through video conference. Thank you everyone for watching this video. I tried to cover all the aspects of circular. Please let me know if you feel anything is left or if you have another interpretation of any provision. I hope you like this video. Please do like, subscribe and share it with all your friends.